Hallmark Institute of Professionals. Register for Business Management, ICT, Sales and Marketing, Purchasing and Supplies, Banking and Finance, Community Development, Project Management, Graphic Design and Digital Marketing. Enhance your professional competency as a CHRPK, CPAK, Certified Secretary, Insurance Specialist, Trust Secretary and courses in Pension Management. Check out our annual training calendar and corporate trainings on our website or call us on 0708 355 941 or 0700 031 162 or visit our offices at Caxton House opposite GPU in Nairobi. Hallmark Institute of Professionals, transforming lives.
Good evening, ladies and gentlemen. It's once again an honor to have us on board. I want to appreciate each and every one of us who has made it to join the session today. I don't want us to wait any further. I know today, being a Tuesday, is an interesting day and being an unusual day. But with those of us who are already on board, we would want to take off so that we are able to finish on time. And we are picking up from where we stopped last time. If you remember, we were able to extensively cover some of the topics that we had shared, that we desired to share with us. And so at this particular time, I would want us to pick up the second part of the conversation that we were to have. And without wasting much time, like we said, the rest will catch up with us. From last time, we were able to have a presentation on the unclaimed financial assets and what basically they do, what kind of assets they have in custody, why were they formed, how we can be able to know the assets that they have or they hold in trust for us. And basically everything around that. And then we had also another presentation from Annette talking about the legal aspects of property acquisition, joint ownership versus co-ownership, separation and divorce in regards to matrimonial property. And that is another one of the areas that we felt needed to be covered extensively, because even most of the questions that were coming through were related to that area. And then after that, we are privileged to have Annette with us once again, and she will be looking at succession and inheritance. And then finally, she will look at dispute resolutions. And then we will have a time once again of questions and answers. And so I would want to really to give us enough time to be able to listen to her, so that we are also able to, there are a few questions that were asked that last time that we were not able to handle, and there are those that we have been able to handle, but today she will also be handling a few of those questions. So at this particular moment, I would just want to, even as I confirm that I am audible, I want to request one of us to open for us with a word of prayer. And I want to take this honor, or to give this honor to the person who was the first to join the class today. And that is none other than our participant, Faith. So Faith, I give you a minute to open for us with a word of prayer, so that I am also able to confirm that I'm audible to all of us. And then after that, I will invite Annette to begin to share her screen and tell us what she has for us today. Faith? Faith, if you were hearing me, you can unmute. Okay, and she says she's on the road, so she may not be able to pray for us. Allow me to pray for us so that we save on time. And in the meantime, Annette, you could be preparing. I've already enabled you to be able to share your screen. So once I'm done, I'll invite you so that you can take it on. Let's pray. Our Father in heaven, we honor you this evening. We give you all the praise, all the glory, and all the honor. We thank you once again for the opportunity to come together and learn on matters property, the legal aspects of property acquisition and everything related to it. We commend ourselves to you this evening, and I pray for every participant that you enable us to learn even as you may desire of us. We declare your blessings also upon our presenter and our trainer for the day. May your grace be upon her, even as you use her to equip us and to give us the knowledge that you desire for us to learn, to the glory and honor of your name. For it's in the name of the Father, the Son, and the Holy Spirit we do pray and give thanks. Amen and amen. So I'll invite Annette once again. Thank you so much, Annette, for creating time once again to come and continue to equip us. Last time was such a success, and we thank God for that. And so I just want to give you this opportunity. By the virtue of the fact that you've shared the screen, I think you're good to go. Karibu sana, and let us delve into this and hear what you have for us today. Thank you.
Thank you so much, Irene, and thank you so much everyone else who's present. I just want to confirm that you can hear me and that you can also see me.
Yes, we can hear you, we can see you, and we can see your screen.
Okay, thank you so much. Thank you, everyone. So I'd just like to start by apologizing. Yesterday, I had to call a rain check because it just became a crazy day yesterday. But today, I'm grateful for those who've been able to join, regardless of the postponement, which I apologize for. And hopefully, even within this very cozy group, we will be able to learn a thing or two. So I'm going to cover two aspects of the presentation that were meant to be covered last week, which is basically going through succession and inheritance, and then eventually dispute resolution when it comes to succession issues. So last week we were able to cover matrimonial property, and we were able to see what matrimonial property is, and that conversation was mostly within the context of marriage, and then what happens to property after a marriage has ended. Now, succession and inheritance is all encompassing. It includes spouses. It exceeds the marriage in that we also look at children, we look at parents, we look at half-children, stepchildren, children who you took in as your own, and basically people you are maintaining prior to your death, and what happens to them when you're gone because they were relying on you. So without further ado, I will begin. I'm trying to move my slide. Okay, perfect. So as I've said, we, just like last time, we're going to look at the regulatory framework regarding succession. And I've said it's all encompassing. It includes basically, it's a concept of what happens to a person when they die. And additionally, what happens to their beneficiaries. And in the case there are no beneficiaries, what happens? It talks about succession law also goes into the procedure, the legal procedure of trying to lay a claim to a person's estate and to be able to legally and lawfully administer the estate of a person who has died, so that the people who really need to be taken care of are well taken care of, and that the assets of the deceased are distributed in a fair and just way. So we'll start by looking at the regulatory framework. And of course, we look at the Constitution of Kenya. And as I said, during our last training last week, the Constitution of Kenya has pertinent provisions on family, the importance of the family, has provisions on the right to marry and to start a family, and the right to acquire property and property rights of individuals and of citizens. So we can get little ideas or other principles from the Constitution that then inform what our succession law is like. Then we have a very specific and principled act that addresses succession issues, which is the Law of Succession Act, Cap 160. And this will be the principal act that I will be focusing on throughout this presentation, because then it forms the basis of our conversation today, and it informs largely the process of succession in Kenya. Then we have the Marriage Act, and because there's a correlation between matrimonial property and succession and marriage, so the succession is interdisciplinary in the sense that there's the issue of succession, there's the issue of marriage, there's the issue of property, and that's where the Marriage Act comes in. Because the Succession Act always, or rather when it is defining who are spouses, it refers back to the Marriage Act. And from there, we can then tell, or we can then determine what the rights of a spouse are, or a spouse, what the rights of a spouse in succession are. Then we also have the Matrimonial Property Act, which I covered extensively last week. And basically then that determines what matrimonial property is. But in this case, it's correlation against succession and the distribution of a deceased person's estate. So the Law of Succession Act, this was an act of parliament that was passed in 1980 to consolidate the different regimes of succession that were there depending on a person's race. So the Hindus had their own form of succession, Muslims do, and largely up until today, Muslims are exempt from the provisions of the Law of Succession Act, except a very specific section that provides on the duties of administrators. But other than that, before 1980, really, there wasn't a consolidated act to address issues of succession in Kenya. So after 1980, then we had the act that was passed to amend, define, and consolidate the law relating to interstate and testamentary succession. And I know these are complicated terms. For those who've never encountered them before, I will explain what interstate and testamentary succession is, and basically the administration of deceased persons. It was most recently amended last year on 17th November via the Law of Succession Amendment Act. And there were some salient amendments that were made to that act, which also made a lot of noise on social media. You may remember last year when people were discussing how side chicks have been left out from benefiting from their sponsors' estate. So it has a lot to do with the amendments brought about on 17th November through the Succession Amendment Act, which we'll look into. But at this stage, I'd like to discuss the key provisions of the Act. So what I'm going to do throughout this presentation is provide you with a very high-level summary, easy to understand, an overview of the Act. It's basically sort of a beginner's guide to succession and succession law in Kenya. So what are the key provisions of the Act? It provides for the legal effects of wills. It provides for the provision of dependents. And I don't know, maybe someone in this call has a will in place. So we look at the legal effect of wills, we will look at provision of dependents, and we'll also determine who are your dependents. When you die, who should rightfully benefit from your estate? Those are your dependents. We will talk about gifts in contemplation of death. And gifts in contemplation of death are those gifts that are made outside of a will when a person is anticipating that I am going to die. Therefore, I want this gift to come to you and how that takes effect. We are going to look at interstasy, which is the most common form of succession in Kenya. This is when a person dies without a will. They are said to have died intestate under the law, and that's the term, the legal term, for a person who has died without a will. They have died intestate. And because of our African traditions and our perceptions towards wills, most Kenyans actually die without a will. So there's a whole procedure under the Act on what should happen when a person dies without a will. We will look at jurisdiction issues because we have people who are blessed enough or exposed enough to have properties in multiple jurisdictions, to even have beneficiaries in different jurisdictions. But you have children in Kenya, you have children in America. What happens, or what right or claim do they have to your property, despite the fact that they're in different jurisdictions? We look at responsibilities of personal representatives. And who is a personal representative? It's either a person who, by way of your will, you have appointed them to administer your estate, to execute your estate when you're gone. Or if you die without a will, the people who will get letters or approval from the court to be able to administer the estate in your absence. Finally, it provides various aspects of dispute resolution and how to challenge a succession process when it's already underway, and mostly by people who feel aggrieved by that succession process. I will now proceed to cover key concepts under the Act, and generally, not even really under the Act, when it comes to succession matters, a spouse is very, very important. But because of the nature of African culture and human nature generally, a person can have more than one person who consider themselves to be the spouse of this person. So who is a spouse? And remember, I mentioned that the Act had been amended in 2021, last day in November. And the Succession Act hadn't defined who a spouse is. It had defined who a wife is, but not a spouse. So now the amendment that happened last year basically amended the Act to introduce the definition of the term spouse. And it says that a spouse, so the previous definition is basically means a husband or a wife or wives recognized under the Marriage Act. And so that amendment basically provides that it means a husband or a wife recognized under the current Marriage Act. If you remember my presentation last week, I said that all marriages are now required to be registered. And we have different types of marriages under the Marriage Act. We have Hindu marriages, we have Islamic marriages, we have Christian marriages, we have civil marriages, and then we have customary marriages. So those are the 5 avenues through which you can get married in Kenya, depending on your situation or your religion or how you want to do it. And there's a requirement now under the Act that all these marriages have to be registered, including the customary marriages. And for you to be recognized as a spouse, you have to be married under those 5 avenues under the Marriage Act. And over and above that, these marriages have to be registered. And this is where people came in and said, the side chicks are essentially being locked out. Because if a man buys a house for me, expresses his intention to have me as his wife, we don't formalize it in any way. I'm living in this house that this man built for me. I have children with him. He dies. Am I a spouse? Then we go back to the Act and we see that a spouse is a person is a person who's married under a legally recognized marriage. But was I married to this man? Not quite, because there's no evidence to demonstrate that we were married. Or even if we did a rorashio, we did a koito, we did a traditional ceremony, but we did not register it. Am I a wife? No, because a marriage or a person who should be recognized as a spouse is a person who has gotten married under a legal recognized marriage under the Marriage Act #1, and that marriage has to be registered. So now we are encouraging spouses while you're alive, you can regularize this. If you got married in a customary way, if you're not married in the church or in a civil marriage, usually those ones, registration is usually taken care of because you're given a certificate of marriage. But if you did a customary ceremony, go and register right now. Because should one spouse die, you will be at loss on how to demonstrate that you're a spouse of this person in the absence of a marriage certificate, because now all marriages should be registered. So a spouse is a very important concept under Kenyan succession law, and a spouse is a person who, and a spouse has a meaning under the Marriage Act, and basically a person who has gotten married under the avenues of marriage in that act. Then you may ask yourself, who is a dependent? A dependent in the first instance is a wife, then children of that wife, or the children of former wives, whether they were maintained or not maintained prior to the death of the deceased person. Then number 2, a former wife can be a dependent, but only in the instance where they were being maintained within 2 years prior to the death of the deceased. And this was an introduction that was introduced by the Amendment Act last year. Before that, a former wife was actually a dependent, whether they were being maintained or not. But after that amendment, a former wife, to lay claim to the estate of a deceased former husband, has to demonstrate that they were being maintained 2 years prior to the death, at least 2 years prior to the death of the deceased. Then now we have parents, step-parents, grandparents, grandchildren, stepchildren, or even children whom the deceased had taken as their own, and they were being maintained prior to the death. And the key over here is being maintained prior to the death of the deceased person. And then the last one is a very interesting one. A husband whose wife has died. Yes, he's a dependent of his wife. And this is an amendment that was brought about by the Amendment Act of last year, November 2021. Previously, before that amendment, a husband could only be viewed as a dependent to the extent that they were able to demonstrate that they were being maintained by their wife. But now it's not necessary that a husband has to prove that his wife was maintaining him. As long as there's a registered marriage demonstrating that he is indeed the husband of this deceased wife, he is a dependent for all intents and purposes, and therefore has a claim to the estate of the deceased wife. So another important concept in succession is a will. And you may ask yourself, what is a will? It's a legal declaration by a person of his or her wishes and intentions regarding the disposition of their property upon their death, and it's executed according to the procedures or according to the provisions of the Act. So a will is a statement. It's a declaration that you make. And in this declaration, you will say that, should I die, this is what I want to happen to my property. These are the people who are depending on me, and this is how my property should then be used to cater or to take care of the people who I have left behind. So there are two types of wills under the Act. You can have an oral will or you can have a written will. And before we begin, I cannot emphasize the importance of a will, because I remember around 5 years ago actually, in 2017, I used to be a member of a certain gym. And I remember there was this lady that we used to work out with over there, and myself and her, we got talking. And I remember asking her, and I remember we just spoke, and she told me that she's recently married and that she has one, and at that time she had one child. And this was a child who she got previously, before she got married to this person, and this man was not her husband. She then told me that, actually I have prepared a will. And I asked her, my goodness, I was a young lawyer then, and I still had that African perception of preparing wills. And I told her, but you're too young, you're in your early 40s, why are you preparing a will? Like there's always this apprehension around preparing a will. And she told me, Annette, I am a single mother in essence. Despite the fact that I'm married, anything could happen to me. And remember, my husband is not my son's father. I really want my son to be protected when I'm not here. And I thought, okay, that's a valid reason, but your life expectancy is very high and it's highly likely you're going to be here 30 years from now. Anyway, last year, this lady actually passed on. And when I got the news of her death, my mind then rushed back to that conversation that we had. And I was like, oh my God, she was so right. She was so right. And I remember then following up on updates of now her funeral and things like that. And after her burial, we still got an update that her will was now going to be read and that her estate was going to be administered according to her will, and all her properties. She'd essentially then, before her marriage, she then bequeathed them to her son, because her son was now joining university. At the time of his mother's death, he was 18. And so he was entering university. And I can see now, from that situation, I can see the importance of thinking forward. Remember, we won't always be here. And unfortunately, because it's life, some people will exit a little too early when they're a bit young, with young children. It is therefore important that these children are provided for, and that is where the place of the will comes in. So you have two types of wills, an oral will or a written will. An oral will is only valid if it's made in the presence of two witnesses. And most importantly, when I make an oral will, I must pass on within 3 months of me making that oral will. So an oral will is very interesting because there have to be people then who will say that, yes, within 3 months of this person's death, they actually called us and they told us that this is the way they want their property administered. And this will probably work for people up country, for people who are illiterate, for people who don't have access to lawyers to draft wills for them. So a great grandfather or an old man in the village would probably use an oral will to determine how his property is going to be done if he anticipates that he's sick and is going to die. Then you have a written will, which we always encourage our clients to do. And this written will, it must be signed and it must be attested by 2 or more competent witnesses. Then there's something called a codicil or additional papers. This can form part of a will. Because remember, I may write a will today, but then I acquire more property, or I get children, or even more children. I will want to update my will. So I can do this by way of either drafting a new will and revoking the old one, or by way of a codicil or additional papers. And this will form part of the will. As long as in the initial will, I would say that any other codicil, any other amendment to this will form part of this will. So that is how you take care of any other future documents that will form part of your will. And then under the Act, a person making a will must be of sound mind. It is very crucial that a person making a will is really understanding what they're doing. And in disputes and for matters that have been taken to court, a person, it's important that when you're contesting a will or on the basis of sound mind, you have to demonstrate that this person was not in a position to know what they were doing. That is the judiciary standard for determining whether a person had the capacity to enter a will. The judiciary standard for sound mind is that the person was in a place where they could understand what they were doing. So if a person is suffering under a mental illness or a physical illness, or they're drunk, or any other circumstance in which they're not understanding what they're doing, then in that case, it can be challenged that they do not have the capacity to draft that will. Either they were then being influenced by another person because they didn't know what they were doing, and that will can be invalidated. So I will cite one case. It is a very popular case, the Kirima siblings and the way they fought. They fought against their father's fourth wife, I believe, regarding his will. So there's a will that he drafted that was being challenged by his children. And this will was drafted when he was almost dying. At this point, he was senile. And in those pleadings, it was indicated that he was even blind. He was even blind at the point of, at that time when he purportedly signed that will. And you could see that at this time, he really didn't have the physical ability to draft a will. He did not know what he was doing. And it was demonstrated that it was highly likely that he was coerced and unduly influenced by his fourth wife at that time. And therefore, that will was revoked. And other directions were given regarding the distribution of the estate of the family. So a free will, being of sound mind, these are two imperative and mandatory components of having or making a will and for holding that will as valid. And in a will, a testator, the person writing the will, may appoint an executor to be able then to carry out their wishes under this will. So before I get to revocation and alteration, I can witness a will in which I'm a beneficiary, and it does not affect the fact that I'm a beneficiary in that will. Remember, a person can challenge. For example, my husband is writing a will. Then at the point of signing, I am an attester. I am there to witness him signing. And I will also sign that document as a witness. But at the same time, this will is also providing for me. So the Act provides that, people can say, how can you be a witness? You're not independent because you're still benefiting. But this does not challenge. It does not challenge the fact that I'm a beneficiary. As long as that will was drafted when that person was of sound mind and without coercion, then it is still valid. So a will can be revoked or altered at any time. And you see, for example, I draft a will and I list my properties, but I encounter a situation where I want to sell some of my properties. And so while I sell my properties, that property does not then form part of my estate anymore because it belongs to someone else. So a will can be revoked at any time when a testator is competent to dispose of his property at free will. So at any time I can dispose of my property, I can actually revoke my will. And revocation can only happen either by drafting another will or another codicil. And then after I draft this other will, I will indicate that any other document, any other will that I have drafted as of the date of this new will, and upon me signing this new will, is invalid because I've signed a new document. That's one way, by signing another will or another codicil. Number two, you can revoke a will by burning, tearing, or otherwise destroying the will with the intention of revoking it. So it's important over here. You have to demonstrate that you don't want that will to exist anymore. So you burn it, you tear it, you basically destroy it. It's not enough. There was a case where a testator basically deleted, or rather used a pen to strike through the provisions. But he wasn't doing it properly because some of the provisions were still visible, were still legible, and some parts were not even deleted. That will was held to be still enforceable. You have to destroy it to a point where it does not exist anymore, where the provisions cannot be read. Then, when you make a will before you're married and then you become married, that marriage effectively revokes that will, unless I am drafting that will in contemplation of marriage to a specific person. So like my client, when she got married, she drafted that will in contemplation of the marriage she was entering into, but with the intention of really protecting her son more than anything. Then any alteration, obliteration, or interlineation will only be valid if the testator signs against it. So sometimes I may want to either, for example, I've made an error, I strike through, or I either strike through and remove a property from my will. For it to be valid, for that obliteration or interdelineation to be valid, I have to sign against it, opposite it, or somewhere close to that deletion. And where I've revoked a will, I can revive it by re-executing another will, or re-executing another will. So a will can be revoked at any time. It can be altered at any time as long as the testator signs and in the presence of witnesses, and then it can be revived by way of re-execution. So now, provisions for dependents. Remember, there are some people who are left out of a will. And in the unfortunate circumstance, for example, we have seen where a man per se has many wives, has never disclosed this, has children who has never disclosed in the duration of his life, and he leaves them out of the will. And remember, these children are being taken care of, or even if they're not being taken care of, it's in their interest that they're listed as beneficiaries in the estate of this deceased person. So persons who've been left out of a will can apply to the court to be provided for. So a will is not necessarily final if there are people who have been excluded and that they can demonstrate that they're dependents. And remember, you have to go back to the definition of a dependent. Who is a dependent? So if you're a dependent and you fit that description and you've been left out from a will, you can actually apply to the court, and this is part of dispute resolution, to apply to court to be listed as a beneficiary and to be included as a beneficiary to the estate, even if the will left you out. So the court will use its discretion in determining whether to include this person as a beneficiary and in determining the beneficiary. And they will look at certain things. They will first look at the nature and the amount of the assets of the deceased. Can they take in another beneficiary? Then they will also look at the reasons for being left out of the will. Remember, some parents actually deliberately exclude some of their children from their wills. So they will look at why were you left out of the will? Is it because you were not nice to your parent for the duration of their life? You treated them badly and they excluded you. They will look at the existing and future needs of the dependent. If it's a child, it goes without saying that this child is going to grow up, and as they're growing up, they need to be taken to school, they have healthcare needs, they have real needs they need to be taken care of. But now an adult, and I will refer you to the case there's this prominent politician, Jenga Karume, and there's this son of his who he got, I think, with a house help almost 45 years back, who he never disclosed. But this child always knew that Jenga Karume is my father. And as an adult, when his father has now died, he comes and claims an interest to the property. Is he a dependent? Not quite, because he doesn't fit the definition of a dependent. But even then, another thing is he was claiming for the interest, or rather all the money that he could have received or to be compensated in regards to the lifestyle he could have lived if his father had acknowledged him. But you look at this person, for me, I thought it took audacity and some sort of self-esteem and confidence, because this is an adult who can actually provide for themselves. And the court in this regard looked at his existing and future needs of the dependent. He's of sound mind, he is healthy, he can go to work and provide for himself. So what he was claiming really couldn't be given to him. So you look at the existing and future needs of the dependent. Then you look at the conduct of the dependent to the deceased prior to the death. And this is why I was saying, how did you treat the deceased before they died? If you are horrible and particularly difficult to the deceased, perhaps even hastened their death, the court will take that into account and possibly deny you your claim to this estate, because there must have been a reason why the deceased person left you out of the will. Then it should look at the situation of other dependents. As much as you're an additional dependent, we also have to balance your interests against the interests of other dependents, and also taking into account how many assets are over here and how much money does the estate of the deceased have. Then we also have something called gifts in contemplation of death. And like I earlier said, this is when I don't have a will, but I'm anticipating either because I've suddenly fallen ill, I'm told I have stage 4 cancer, or I'm in a situation of danger, like in the middle of where I anticipate that I will not make it. Therefore, I'd call my sister and I tell her, this property, I have a plot in Syokimau or in Kiambu. I want you to have that property because I anticipate that I'm going to die. This gift in contemplation of death is actually valid and it's enforceable by law. But it must be made when a person is contemplating or anticipating death due to an illness or present or imminent danger. Then that property should be capable of being disposed by a will. So if I was okay and I drafted a will and I can dispose of that property by a will, I can certainly bequeath it to a person if I'm contemplating that I'm going to die. And then there should be delivery of ownership documents to the beneficiary. So if I have the title, I will give it to my sister and I will tell her, here is the title, I've given it to you. And if I die and any dispute arises, she will say that my sister was, number one, contemplating death, and number two, she delivered to me the ownership documents of that property. Then another key aspect of a gift in contemplation of death, there must be the intention that that gift will revert to me should I survive death, or should I survive that illness or the danger. So it should be on the premises that I'll tell my sister, if I die, you take the property. But if I live, I will then take back my title, it will revert back to me. And then the gift in contemplation of death is still valid, even if I die from any other reason except the one I had earlier anticipated. So for example, if I had stage 4 cancer, but I walk out and I'm hit by a bus and I die, that gift in contemplation of death to my sister is still valid. However, if I die by suicide, that does not apply. And then a person may request back for the gift before death. So anytime before I die and I change my mind, I can actually tell my sister, please bring back my property. Then there's interstasy. Like I said, some people die without wills, and that's what interstasy means. So in this situation, that the interest of a spouse, their child or children, when this person dies interstate. So for example, if my husband dies and he didn't leave a will, my interest as a spouse, all his personal belongings will automatically vest in me. All our household goods will automatically vest in me. Then the residuary of the estate will be distributed amongst our children in equal shares. Or if we have one child, it will vest in our child. If we have many children, it will be distributed equally among those children. Then there are instances of death where there is one spouse, but there are no children. In this situation, then, the property will vest, the personal and the household effects of the deceased will vest absolutely on the surviving spouse. Then the first 10,000 shillings of the estate, or 20%, whichever is higher, will vest on the wife absolutely. Then on the remainder of the estate, the wife will have a life interest in that property. So number one, the personal items and the household goods will vest in me absolutely. Then after that, 10,000 shillings or 20% of the estate, whichever is higher, will then also absolutely vest in me. And that is why we don't have children. Then the rest of the estate, I will have a life interest in it. But this life interest will determine where I remarry. So if I find another man after my husband has died and I marry him, my life interest in my previous deceased husband's estate will then stop, and it will no longer exist. So upon determination of the life interest, the property subject to that interest shall devolve in order of priority set out under the Act. And that order of priority is, so when my husband died, we don't have children, I have a life interest in the property, but I remarry, that life interest ends and it will devolve in order of this priority. It will go to his father first. Then in the absence of his father, it will go to his mother. In the absence of his mother, it will go to his brothers and sisters. In the absence of his brothers and sisters, it will go to either his half-brothers or half-sisters. And in the absence of that, it will go to any other relatives up to the 6th degree of consanguinity. And in the absence of these relatives, it will then vest into the state and will enter into the consolidated fund, the country's consolidated fund. So what is the power of a spouse during that life interest? I have the power to administer the estate of my husband when I have that life interest for the interest of myself and any other beneficiaries, including beneficiaries who in that case would be my children. Then where a person has left a surviving child or children with no spouse, the estate of that person will vest absolutely to his children. If it's one child, absolutely to that one child. If it's many children, it will vest to those children in equal shares. And then where the intestate has left no surviving spouse or children, it will go back to that order that I had earlier stated. His father, if not his father, his mother, if not his mother, his siblings, if not his siblings, his half-siblings, if not his half-siblings, his relatives up to the 6th degree of consanguinity, and also those ones are not there to devolve into the state. Then, if a man dies and he was polygamous, his estate will be, and he died without a will, his estate will be distributed according to the houses, the homes that he had, and each wife then has a home. So if he had 3 wives, he'll be considered to have had 3 homes, and it will vest in his children from the homes depending on their needs. And his wives will be considered to be additional children under these homes. So that's how the property will vest. Based on the families, the different families that he's had, each of the spouses will be considered to be a child, and the property will be distributed amongst these homes depending on the needs of this home. So for example, the first wife might have adult kids who are already working and can take care of themselves, but the last wife has young children. So in such a situation, the last wife would probably deserve a little bit more to take care of her grandchildren. Then there's the aspect of survivorship. In the unfortunate circumstance that both spouses die at once. And when I was looking at the Act and looked at this section on survivorship, I remembered a friend of mine from university who lost both her parents in an accident, and they both died in that accident. So, but what was interesting was that the father died on the spot. The mother survived but was taken to hospital, but then later on died. So where spouses die on the same day, or where spouses die together, the estate will be devolved in the fact that the first person or the first spouse to die will have left their property to the second spouse, who then dies, and that property then will devolve to the beneficiaries in that order. And then where it's not clear who died first, the older person will have been considered to have died first. So where they die simultaneously, when they die together, the first person who died is believed to have been survived by the second person who died. Then when they died, the interest then goes to other beneficiaries like their children. And where it's not clear who died first, the older person is deemed to have died first. But it's important to note that there are certain communities, ethnic communities, that have been excluded from the provisions of the Act on Interstasy. And these are communities in the northern frontier: Turkanas, Samburus, Boranas, Somalis. And this is mostly because they come from pastoralist communities. And their assets, such as land, were bequeathed on communities, mostly not individuals. So it becomes a little bit more complicated when it comes to distributing the properties of these communities where a person has died without a will. So what the Act provides that if you come from Turkana, and it has listed these communities, if you come from West Pokot, Turkana, Marsabit, Mandera, Wajir, Garissa, Tana River, Narok, Samburu, Isiolo, Lamu, or Kajiado, and you die without a will, the provisions of the Act on Interstasy will not apply. What will be taken into account, or what the courts will take into account should a dispute arise, is the customary law of these communities, because most of this property was community property. So it's the customary laws that will then determine how this property is divided. So you have to be really careful. My take would be, if you belong to any one of these communities, it's then important that you draft a will, because customary law can sometimes be repugnant to the interests of women, the interests of children, and sometimes can sideline people. So it's important that if you come from these communities, to draft a will that you can be guided by that, because if you don't, then your estate will be distributed in accordance with customary law, which may exclude some of your beneficiaries. So now I'll go to things called grants. Remember, if my husband dies today, I just don't wake up and decide that I'm going to sell his properties or I'm going to deal with any of his assets. I have to get something called a grant, and this is provided for under the Act. Whether a person dies with a will or without a will, the people who remain behind should get a grant before they move to do anything with this property. And the Act provides there's no distribution of capital, and capital refers to the assets of the deceased. No assets of the deceased can be distributed before a grant is made. However, if there's income from these capital assets, that income can be used. So in this situation, if my husband dies today, I can then not next week without a grant start selling off his properties. But if he had properties that perhaps had flats erected on them, or apartments, and he was gaining income from these flats, I can use this income and distribute it amongst my children or amongst beneficiaries for their needs. So assets cannot be distributed, but income from the assets can be distributed, especially where there are pressing needs and where the beneficiaries were being maintained by this income. Then, so for a will, a person who dies under a will, the executor of the will be given something called a grant of probate. If I die without a will, my personal representatives will be given a grant of letters of administration. So those are the two differences. Where there's a will, executors are given grant of probate. Where a person dies without a will, what the beneficiaries or what the surviving people are given are letters of administration. Then, when it comes to letters of administration, preference is given to certain persons to administer where a person dies intestate. So usually preference begins with the wife or the husband. So if my husband dies, the court will most likely issue me with letters of administration. But any other interested parties, and sometimes people agree, it can be the spouse and the eldest child, if the eldest child is already an adult. So there's a preference, and it begins with the surviving spouse, and it comes to issuing letters of administration to a person who died intestate. And what is the procedure of getting a grant? It's important that we pay attention over here, because this is really where the rubber hits the road when it comes to taking care of the estate of a deceased person. Remember, you can't do it without a grant. But how do you get this grant? You file a notice of application for grant. So if my husband dies and he had a will, and he appointed me as the executor of his will, I will go to the court and I will apply for a notice of application of a grant as an executor to then execute my husband's estate. But in the situation where he died, or if he dies without a will, I will approach the court and ask to be given, I will file a notice of application for grant of letters of administration. So the court will receive my application, and then they will advertise it, they will gazette it for a period, and it's mostly 6 months. And within this period, when that application has been filed in the Kenya Gazette, any person who has an objection to either letters of administration being issued to me or to me being an executor will then come within this period and give an objection to the application. And if an objection is filed, the registrar, or rather the court registrar will notify me that there's a person who has filed an objection to you being an executor or you being given letters of administration. And then when this happens, I have the option of making a cross application or responding to this objection. So after those 6 months have lapsed, if there was no objection, I will be issued with a grant. But this is an interim grant. So it will just be a grant, interim grant after 6 months, where I have a will or letters of administration. I will be given a grant of probate where there's a will, where letters of administration are given. I'll be given an interim grant of letters of administration. And in a situation where an objection was filed, but I did not respond to it, I will still be given the grant, the temporary, the interim grant. But in a situation where the objection was filed and I responded, the court will then have to make a decision at that point before they issue me with the letters. So as you would imagine, these 6 months are a very vulnerable and a very critical time, especially for people who are contesting. And these are dependents who've been left out of a will. These are children or other wives who have never been acknowledged by the deceased but are legally married. The children are actually his, and it can be demonstrated by DNA letters that they are his, and that they suffer to be prejudiced severely if they're left out from the estate of this person. So within this 6 months is where an objection has to be provided. Then after the issuance of the grant, another 6 months will lapse. And if this 6 months lapse and there's no other objection, I will be issued, if my husband died with a will, I will be issued with what is called a confirmed grant of probate. And if he died without a will, I will be issued with a confirmed grant of letters of administration. Now, over here, once I'm issued with this confirmed grant, whether he died with a will, whether he died intestate or with a will, as long as I'm given a confirmed grant, no person can come and challenge that confirmed grant. Because remember, they had 12 months, the 6 months before the interim letters were given, or the interim grant was given, and then the 6 months after that grant, the temporary grant was given, to the point now where I'm issued with the confirmed grant. So they basically have a year. And remember, these grants and the application to be given a grant are usually published in the Kenya Gazette. So there it's assumed that they should have seen and they should then have known. So it's important within these 6 months, on 6 months before the issuance of the temporary grant and 6 months before the issuance of the confirmed grant, 12 months in total, to be able to challenge, because after that, you can't. So the powers of personal representatives are then given once the confirmed grants are given to deal with the estate of the deceased. So what are the duties of personal representatives? So when my husband dies and I get a grant of probate or confirmed grant of letters of administration, I will start first by paying out any funeral expenses. Then I will collect all the property of the deceased, and I will collect all money, including debts owed to him, in bank accounts, etc. And this can be done by providing the requisite letters of administration or grant of probate to the banks or financing institutions that were holding deposits due to your husband. Then I will pay any administration costs, basically what I in kind administer in my husband's estate. Then after that, I will pay his debts. Any debts owed by my husband before he died, I will pay them out. And debts must be paid before I start distributing the property to beneficiaries. In 6 months from the issuance of the grant, the temporary grant, I'm meant to provide an inventory of assets. I'm meant to provide a list of my late husband's assets and liabilities. Then I can distribute or retain on trust all assets remaining after the payment and the expenses of my husband's debts. Then I'm required to complete administration of my husband's estate within 6 months from confirmation of the grant or such long a period as the court may determine. So if there's a continuing trust where we have young children who I'm still raising, in that situation, of course, I can't complete administering the estate of my husband in 6 months. So I'm holding this property in trust for my children because they are young. And even if my husband bequeaths properties to them, by virtue of them being underage or the age of minority, they cannot hold this property. So I'm holding them on their behalf. So I'm still administering their property. So in this situation, I will continue holding this property for as long as the court decides it should be the duration of these children's life until they become adults. But in a situation where there are no children, there are no people with disabilities or people who have mental incapacities that I'm holding these properties for trust for. If my children are all adults and my husband then left properties to bequeath to them, I am required by the courts to complete this administration and bequeath these properties and distribute these properties as per the will or as per letters of administration as we have all agreed to my children, and within 6 months then tell the court that we are finished administering the estate. And then the court can ask me on their own motion or on the application of an interested party like a beneficiary to produce an account of the assets and liabilities of the estate of my deceased husband. And then I'm required to complete the administration of the estate in respect of all matters other than continuing trusts. And continuing trusts are usually created by the children who are underage, or where the people who have mental incapacities, or where the people who are ill to the point where they can't take care of the property on their own. So those are the duties of personal representatives. And then now I will proceed to dispute resolution. So you will notice in my presentation, I've covered different aspects of dispute resolution. Basically through the process of trying to get grants for the administration of the estate of a deceased person. Sorry, it looks like my screen is freezing. So I just want to go to the last slide, the very last slide now on dispute resolution. So anyway, it's not reflecting, but the High Court has original jurisdiction for succession matters, and there is even a specific division of the High Court that addresses succession, matters of succession. Then also the resident magistrates courts may also have jurisdiction to determine probate matters, especially if the estate of a deceased person was not so much and it's within the pecuniary limits of those courts. So if you have a matter, if you want to challenge anything, and grants are usually given by the High Court, so that is where you go to challenge either a person being given a grant on the basis that you have been left out, or other beneficiaries have been left out, or that you are being maintained by the deceased person prior to their death. You have not been included as among the beneficiaries, or you have been excluded from the will, and therefore you have an interest and you want to challenge. So basically that would be it on dispute resolution. There's robust and a lot of case law and a lot of jurisprudence that has been brought about through succession law, through basically challenging the administration of a deceased person's estate. And maybe in another forum we'll be able to discuss them. But basically those disputes center around the concepts I've already covered. Was a will drafted? Was it valid? You're challenging the mental capacity of a person to enter into a will. You're saying that there were no witnesses. You're saying that you have been excluded. You're saying that you are a dependent. You want to prove that you are a dependent. You want to say that the persons applying for the grant of letters of administration don't have any right to, etc. So basically dispute resolution arises within those concepts that I've covered and the act is clear on who a dependent is. The act is clear on what a valid will is. So basically, having known what the key concepts are and what the act and the law provides, when a dispute arises, you always go back to what the law provides, what the act provides. So I think we're good to go, and hopefully I've covered it and I've given you the basics, and I hope that we are well informed, and I'll be willing to answer any questions.
Wow, thank you. Thank you so much, Annette. I think this looks like a conversation that can really continue and continue. But I think, like we've always said, it's always important if someone has more need than the information that has been given to us. You've already shared your contacts with us for those who may be interested to get in touch with you. I think it will be very easy. But for the sake of this forum, Annette, I believe you can hear me. We can probably answer a few questions that have come to my attention, and just allow me to read a few of them. And somebody was asking, can a divorced woman inherit the late husband's estate? I don't know whether you want to answer that, or do you, maybe you can just give it 1 minute. Can a divorced woman inherit the late husband's estate? And then I'm going to read the next as we progress.
Okay, thank you so much for that question. So the Act has indicated that a dependent is a wife or a former wife of the deceased person. And a divorced woman is actually a former wife of the deceased person, but there is an exception. It's not enough that you're just a former wife. You have to demonstrate that despite the fact that I was divorced, this person was still maintaining me. And as recently as 2 years before their death, they were still maintaining me. And that was the dilemma that was there before the amendment to the Act last year in November. Because remember, I could be divorced from someone, I could be estranged from someone, we do not talk for 10, 15 years, he's not even maintaining me. He remarries, he gets young children, but the moment he dies, I then come in and say, no, I am a former wife. And the Act clearly provides that a former wife is a dependent whether or not they were being maintained prior to the death of the deceased person. So this was a problem because essentially it was almost unfair for a person to come and claim from the estate of a person they have not spoken to in 10 years. There was no maintenance arrangement, and perhaps the beneficiaries who have a more pressing need for that estate and for that property compared to them. So currently, under the current Act, based on the amendments that were done last year in November, a divorced woman is a former wife, and yes, she can benefit or have a claim against the estate of her former deceased husband, but to the extent that she can demonstrate that in the past 2 years, he has been actively maintaining her. So I hope that adequately responds to the question, Irene.
Yeah, I believe so too. And I think are you able to read the charts?
Yes, I am.
Yes, so you can begin from the number 3.
Yes, so number 3.
No, we have a number 2. Yeah, so from number 2, whereas the person says, I got divorced 3 years ago. My matter has not been heard. Every time the judge is away on official duties, or for 4 occasions, the matter has been pushed. I am almost giving up, and it's about matrimonial home that is jointly owned. Your comment on that?
Thank you so much for this question. And first of all, I'm sorry for all of this. I am aware and I'm privy, despite the fact that I'm a transactional lawyer, I don't go to court often or at all. We have a disputes team that does that. I am aware of the delays in the judiciary and how frustrating it can be when you're pursuing justice. And a divorce in itself is not easy to begin with. And then now you have a dispute when it comes to matrimonial property. So I appreciate the sort of frustration that you're going through and the difficulty that you're having right now. So the Civil Procedure Rules 2010 and the Civil Procedure Act itself provides the principles of proper judicial service, and that a matter should be determined in an expedited manner. And the courts have a responsibility to respond to complaints where matters are not being dispensed with in an expedited manner. And they have a responsibility to parties who have come to seek justice to ensure that these matters are dispensed with in an expedited manner and as fast as possible, so that parties can then get proper justice and can get the rights that they have to the various things that they're claiming, like in your case is matrimonial property. So one practical thing that I would suggest right now is to write a formal complaint to the registrar of the court where your matter is being heard, to formally complain on how long this has taken, because then they have a responsibility to respond and explain to you why, despite your many follow-ups, your matter keeps being adjourned. It could also be possible, I don't know, that the party on the other side, your former spouse, could also be frustrating this or making the file disappear, or for some reason the file just can't be accessed. I don't know, I'm just thinking from the top of my head. But this happens to many people. You can also apply for the file to be kept in safe custody with the registrars, but it doesn't go to the general registry where files are where people are paid to steal and hide files. Another thing that I would suggest is for you in the interim to get interim injunctive relief in respect to your matrimonial property until the matter is decided. So you can apply under what we call a certificate of urgency for the court to give you interim orders so that your other spouse, your former spouse, does not deal with your property in such a way either they cannot sell it, they cannot lease it, they cannot charge it until a decision is made by the courts regarding matrimonial property. So those are some of the practical things you can do to safeguard yourself in the meantime. And this is a stretch, but also perhaps if the other spouse is amenable, if you are in talking terms with them, you can enter into a settlement agreement as to how that property will be distributed between both of you. But I take it that if it's in court, it's a dispute. You probably weren't able to arrive at an amicable solution on how to distribute that property. So I think in the meantime, you can follow those three practical aspects I've given. You can write a formal complaint to the registrar of the court. You can ask for the file to be kept in the custody of the registrar. Then you can seek interim orders, preventing your spouse from doing anything with the property until a decision is made. So I hope that answers the question.
Yeah, thank you so much. I think you've tried your best. Then you can pick the next question. I think they keep coming. I've decided to post them on the chat so that we are able to move with speed.
Okay, I'll try and move a little bit faster as well in the interest of time. Kevin says, thanks a lot, Annette, for the presentation. My pleasure, Kevin. Then the third one is, if a spouse consented to buying a property, but did not contribute to repayment of the mortgage, and later they divorce, can the spouse come later and claim part ownership of that property? Yes, they can. So first of all, they consented to buying the property, but they do not contribute to the repayment. Remember what I covered last week. Contribution does not necessarily have to be monetary. It can also be non-monetary contribution. So if she demonstrates that she was taking care of the children, she was taking care of the home, she was working in a family business, she was offering you companionship, to the extent that she can prove that she contributed non-monetarily in those aspects that I have just covered, then she has a claim to part ownership of that property. She probably did pay for the mortgage, but she can say that, or she can demonstrate that I took care of the kids, I took care of their welfare, I was working in a family business. I offered my husband companionship. Therefore, he was in a place where he could adequately work and repay for the financing. And this property, we obtained it when we were married. So it's matrimonial property, number one. And number two, if she can prove contribution, it doesn't have to be monetary, she has a claim. So I hope that answers. Then number four, is that okay, Irene?
Yes, please.
Okay, then number four, when people separate, how does one ensure children inherit from their father, even if he has moved on? So as I said, under the Succession Act, children are beneficiaries. Children are automatic dependents of the deceased person, whether he was maintaining them or not, whether he had moved on or not. So when his new spouse is going to apply for letters of administration, or if there's a will and this father has excluded these children, that will or that process of getting letters of administration can be challenged on the basis that these children are actual dependents. They're described, defined, and recognized as dependents under the Act, and they have to be included in the estate of the deceased person. So your question is, how does one ensure children inherit from their father even if he has moved on? First of all, is he providing for them? And even if he is not, if he dies, in the event that he dies, it's very important that you become very proactive and that you follow that any application that is made for the distribution of his estate, if it excludes these children within that 12-month period of issuance of the confirmed grants, to be able to challenge and ensure that these children are then listed. That's how you go about it. Unfortunately, if they've been excluded, the only option is to go to court to have them included. Then, what happens after a divorce where there's children, and at what point is divorce deemed to have gone through? So where there's children, as part of the divorce, if parties have agreed, if there's no dispute as to the custody of the children, then whichever spouse is then, after both parties have agreed, if, for example, me and my husband divorce, but when it comes to custody of the children, it's amicable, then in that case, if we decide that I'm going to keep the kids, he's gonna be visiting maybe twice a week, or they're going to his place every other week, and there's no problem. If it can be agreed between the parties, well and good. But remember, if the divorce is acrimonious and parties are fighting and it's very nasty, the parties can then apply or can seek custody for children in the court, especially where one spouse is keeping the children away from each other. Then the court will award custody as is necessary, taking into account the well-being of the children. Sometimes you can have a very abusive spouse who's abusive to the children. So the court will not necessarily grant full and free custody to that person. But if both parents are willing and really want to have full access and good access to their children, the court can then award custody, to taking into account the rights of both parents to have access to their children. Then parties can also enter into a custody agreement as part of the divorce settlement and register this custody agreement with the court. And we recommend that this custody agreement be entered to at the time of divorce, so that in case in the future any dispute arises in respect to the custody of these children, we have that custody agreement that we can always refer to. And this custody agreement will be also will be filed with the court as part of the divorce settlement. Then there's a question, gosh, there's so many. Where was I, Irene?
Yeah, you are talking about when people separate, how does the does one ensure children inherit? So you could handle the number 5, what happens after divorce, where I think you handled that.
Yeah, so the next one is who has the right to properties, the dependents or the spouse. In this case, the mother died. To inheritance, all dependents or spouse has an upper hand. So like I said, when a person dies without a will, first of all, the surviving spouse will have an absolute interest in the personal items and the household goods of the deceased person. Then after that, the rest of the estate then vests on the children or other beneficiaries. But absolute interest vests when it comes to the personal goods, the personal items and the household goods of the deceased person. So your question is, who has the rights to properties, dependents or the spouse? Spouse has an absolute interest to household goods, personal items of the deceased person, then the rest of the estate goes to the dependents. So I hope that adequately answers the question. And if the person died without having children, what happens then is that the spouse will have an absolute interest on the personal goods, on the personal items rather, household goods, then 10,000 or 20% of the estate, which will absolutely vest in the surviving spouse, and then they will have a life interest in the estate of the property. As long as they don't remarry, they'll have a life interest. And the same thing in this situation, where there's a wife and where they're dependents. The wife first gets personal items, household goods, then after that, the rest of then she has a life interest in the estate, subject to the interests of other dependents. So I hope that is clear. Then the other question is, can a married woman be refused inheritance because her marriage is not registered? Well, currently, yes, because the state is trying to get all people to register they're married. And under the current dispensation of the Marriage Act, a valid marriage is the one that has been carried out under the 5 dispensations, Hindu, Islamic, civil, Christian, or customary, and has been registered. So if you're not able to produce proof of marriage to the person, it's possible that you can be denied an inheritance. However, through case law, people are able to demonstrate, because remember, the Marriage Act came into effect sometime in 2014. But before that, people were actually married under customary law and weren't registering it. The court jurisprudence and case law, and rather the courts have been a bit lenient. If you're able to demonstrate that there was a customary ceremony, that there are people who attended this customary ceremony, you have witnesses who can show that 2 people were customarily married, then you can inherit. But we're encouraging all people who are married under customary law and did not register to go and register, because who knows how long the courts will be lenient. And we've had an act for 8 years now that is requiring people to register their marriages. Why have they not registered? So it's important that you register your marriage. Then in the Kenyan tradition, do married daughters have the same rights as sons in regards to family property when parents are late? Yes. And this is provided for in the Constitution of Kenya. Men and women have equal property rights. And then when you look at the Succession Act, it provides that men and women, both girls and boys, both female and male siblings, have equal right to benefit from the estate of their deceased parents. So now you cannot lock out your sisters, if you're a man, from inheriting your property because they are married and therefore they will probably inherit from where they're married to. As long as they are children of your parents, you both have an equal interest to that property. Then if you're writing a will, must you have the title deed for the land? What then happens in the case of excluded communities? So the Act contemplates a situation where you may not have a will, or you may not have registered interest over the property. As long as it can be demonstrated either that this property was sold to you by virtue of an agreement for sale, it can then be presumed that it's yours, and then it then devolves to your beneficiaries, or is transmitted to your beneficiaries. Must you have the title deed for the land? The answer is no, not necessarily. But where you can't prove ownership, of the property, and you bequeath it to a person, let's say your son or your daughter, and another person then comes in and claims this property by virtue of the fact that they have a registered interest on that property. They do have a proper claim to that property. They can demonstrate that it's registered in their own name, and as such, even at the registry, the lands registry, then does not show that that property was transferred from them to your son or to you specifically. So if you have a beneficial interest in the property, it's okay, you don't have to have a title. But remember, this leaves that bequest open to all manner of challenges, especially if someone has an opposing claim. There's also something called the right of election under the Act. So this is, for example, where I have a property that is not mine. but it's probably registered in my brother's name, and I was holding the property in trust for someone, and before I die, I bequeath it to them. So they have the right to either accept that property as it was bequeathed to me in a will, or first renounce that bequest and come and say, no, actually this property was mine and I will not take it by virtue of a will or by virtue of succession because it was initially mine. So there are many ways you can own property, and you don't have to be the registered owner of a property to be the owner. You can be a beneficial owner. Either you have already bought the property, just that the transfer is not registered, you have a beneficial interest, but it's almost always proper. And this is where estate planning comes in, to be able to tidy up your assets and your property. Even those ones where you bought and you still don't have the title, please procure a transfer of this property to your name, so that when you go, you avoid instances such as this. And then what then happens in the case of excluded communities? In the case of excluded communities, the act is clear that the customary law of that community will then apply when it comes to the distribution of the estate of the deceased person. So it's from Malindi, Turkana, Baringo, the Northern Frontier, and Lamu. Unfortunately, where a person dies without a will, that property will be distributed in accordance with customary law. So I think that's all for the questions, unless someone else has a further additional question, Irene, but I think I've covered everything. Hello, Irene.
Yeah, thank you. Thank you so much, Annette. I think one of my gadgets have been thrown out of the meeting, but it's good that I'm still connected. I just wanted to say, I think that would be sufficient for the day. Like we said, we already have your contacts for anyone who may need further guidance. For the members participating, remember we saying that the recordings will be shared with you. Sorry, we've not been able to share the previous recordings because our technical team was still working on it. But we are working to ensure that is shared as soon as possible, so that you're able to listen again and again, and in case of any questions, then you can reach out to us or reach out to Annette because she has shared her contact. We'll also be able to share the slides for your reference. And so as we come to the conclusion of this session, I'm personally honored to have all of you here. And you will allow me to just probably acknowledge the presence of two people. Annette, for your information today, one of your seniors, at least that I know personally, Mr. Boniface Mwangangi, was one of your students. So I wanted to give him an opportunity to say hi. And then probably I'm seeing also maybe to give one or two more people an opportunity to just say a word in conclusion. And in that case, I'll invite one Dr. Martin Maina, if you're able to unmute your microphone and say a word. And then, and I'm choosing this randomly. Some of us have not met you, but it's such an honor to have all of you here. I think for the sake of gender balance, then I will pick on, allow me to pick on my namesake, Irene Moinket. I hope I'm getting that name right. So we can say ladies first. I've just remembered something that I saw somewhere about ladies on the right, because they are always right. So we have Irene Moinket. You can say hi and maybe just say a comment, and then we will hear from Dr. Martin Maina, and then our senior most, Mr. Boniface Mwangangi, will probably just say a word as we come to the conclusion of this meeting, and then we'll call it a session and look forward to what is coming up next. So Miss MS Irene Moinket, are you able to unmute and say a word, even as you appreciate our presenter for the day?
Good evening.
Good evening.
Thank you very much for this opportunity. As you have heard, my name is Irene Moinket. I just want to appreciate the presenter and for the good presentation. And just to apologize because I have joined the session late, but I hope I will be able to follow with the recordings and maybe other sessions if an opportunity arises. Otherwise, thank you very much for availing these sessions. This is a good platform for us to learn and enhance our understanding as far as HR matters are concerned. Thank you very much and have a blessed evening. Back to
Thank
you.
you. Thank you so much, Irene. We are honored to have you, and yes, you'll be able to access the recordings as well as the slides. We'll give guidance on that along within the week for your consumption. And so it gives me a great joy to invite one Mr. Dr. Martin Maina to just say a word, and then Mr. Mwangangi.
Okay, good evening, everybody.
Good evening.
Yes, mine is just to say thank you for that word of session. Thank you, Irene, for the organization, and of course, the word of presenter, Annette. It was a nice, let me say, learning experience, and we can't be grateful enough. I think we've learned a lot, and we are looking forward to the sessions ahead. But it was a great learning session, and we are very grateful. God bless you.
Thank you so much, Daktari. We look forward to having you in the future sessions as well. Once we post the presentations and the video recordings, you have the privilege of also getting to hear more. And thank you so much for joining. And finally, it gives me great joy to invite our senior most, Mr. Boniface Mwangangi. If you're able to unmute and say hi and maybe a comment, we all learn a lot from you. So it's such an honor to have you sitting back and being a student today.
Thank you, Irene. Thank you, comrades who have joined the class. Annette, congratulations. You have done extremely well as I listened it through. I'm encouraged by you as a lawyer and as a baby girl. I feel proud of you because I can see the line of my daughters. But you need only to check is that provision in that act, just measure it against the Constitution. The one provision in the Succession Act which says that a person can be refused inheritance because if it is a lady, say she has remarried. So what do you do to a man who has remarried as well? Is that provision equal, or what do you do with the rights to property which have crystallized by reason of the marriage? You just check the efficacy of it. I know it is in the law. Just think through it vis-a-vis the Constitution. We can discuss, and I can assist you as we discuss through. Thank you so much, and be blessed. Have a good night.
Thank you so much, Mr. Mwangangi. I'm so happy to hear from you. I'm so happy that you've attended this. Thank you so much for your kind words. And yes, I'm meant to pay you a visit, by the way. So I will look up the Constitution and then we will have the discussion. I'm looking forward. Thank you, Mr. Mwangangi.
Thank you. Bye.
Yeah, thank you so much, great minds. And I think I'm one person who keeps telling Mr. Mwangangi that we really need his mind, and also we would appreciate to see many more coming after him, because we know he is ahead of us in these matters. And I was actually, Annette, I was just telling him earlier on that I am so proud that I can confidently say you're doing justice in this area. And members, as Mr. Mwangangi has said, I think that comment was not just for Annette. It's something that triggers our our curiosity, and I think it would be interesting for us to also go further and begin to seek on these things that are, yes, in the Act, are they in line with the Constitution and all that? And if we find that there is anything that is contradictory or that has a challenge in any way, we have our learned friends, of course, to guide us. And of course, it would be a very interesting debate to have until we find solutions. Once again, on behalf of the Hallmark Institute of Professionals Fraternity, we desire to give you the best as we seek to transform lives by giving you knowledge that will help you to become a different person in the near future that is here with us. We are honored to have all of you once again. Be on the lookout for the next session that we'll be hosting on the life skills, but even much more, look out for our other trainings that are academic, professional, and also corporate trainings. We are also so much into consultancy. We have a key eye on the financial wellness now when we are young, when we are working, and also looking out to a very good retirement. I personally say that life starts at retirement, but with a disclaimer that for only those who plan for it. So in case you have any areas or any gaps in your organization where you need us to have a training for your staff or to work with them through the professional courses, academic programs, we are open to do that. Check us out on our website, on our social medias, share our programs when you can. Remember, as we pour these unto you, we are doing an investment for you. We would appreciate if you can also share with others so that they can be beneficiaries as we continue to transform lives. Other than that, thank you so much. Be on the lookout once again for what will be coming next. Check us on the website, check us on our social media, and let us continue to transform lives together. You are blessed, you are highly favored. I declare the blessings of God upon you, even as you go to rest tonight. May you have a restful night. May you have a fruitful week ahead, and we wish you a happy Easter as we look forward to the next session that we shall have. And now we pray that God, you continue to be with us, even as we prayed when we started. May you continue to be with us and to help us to even apply the knowledge that we have acquired tonight. We declare your blessings upon our presenter tonight. May you be with her and continue to give her more knowledge, even as you help Hallmark to continue transforming lives. For it's in Jesus' name we do pray and give thanks. Amen and amen. You're free to leave.
Amen. Thank you.
Thank you.
Bye.
Thank you.